Let's talk about immigration appeals today. There's lots to learn. It can be confusing and kind of overwhelming, but let's break down the simple steps of when you need to file it, the appeal, where it needs to go, and what is the benefit. Hi, I'm immigration lawyer Hillary Walsh, and I've been doing immigration appeals for over 10 years. It's actually how I got my start in immigration law, was really by specializing in Board of Immigration and Ninth Circuit appeals. I've even written to the U.S. Supreme Court, so I have extensive experience in pretty much every court here on the west side of the United States, and all the way up to the top for federal immigration matters. So I've argued before the Ninth Circuit numerous times. I've argued before the Board of Immigration Appeals. I'm one of the few people in the United States that can say that. I want to share all the info that I can with you, so that as you make the important decision, and it's one that has to be pretty quick decision of whether to appeal an immigration judge decision, a Board of Immigration Appeals decision, or even an asylum office decision or USCIS decision, anything that you don't like and you think, you know what, I need to possibly appeal this. My hope for you today is that you walk away with just a little bit more information, feeling a little bit more confident, having some hope, knowing what your rights and your options are. And if you need help, that you can reach out to me at New Frontier Immigration Law, because that's what we're here for. We're here to help. So let's jump right into it. Let's start first with why appeal, when should we appeal, and how to do it. All of those things all at once, right? First of all, why appeal? The number one reason people come to me and they've got a negative decision in their hands, usually from an immigration judge, sometimes from the Board of Immigration Appeals, and oftentimes from USCIS, they say, what do I do next? This says I have 30 days to appeal, or something basically bad is going to happen. I'm going to lose my case. I'm going to be put into removal proceedings. A notice to appear, which is a fancy way of saying a time to show up for court because we're going to try to deport you, that could be issued if I don't do something in 30 days. And as a starting point, it's important to note that pretty much every appeal that you have to file is going to have a 30-day clock. When does the 30-day clock start? From the day the decision was issued. Now, if the decision was mailed to you, you might get a couple of extra days. I never use those extra days because I don't want to have to explain why this was past the 30 days. And in some situations, it's not even from when you received it. It's from when it was issued, when the decision was issued. So ignore everything else you hear, and let's keep that 30-day clock in our mind for when the decision is issued to when we have to have the appeal in the court systems, in the court's hands for the appeal. We got 30 days for pretty much any Board of Immigration Appeals issue, or what I should say is for any immigration appeals issue. Let's talk specifically about a USCIS decision. How do you find the deadline? There's going to be on page 1, it's going to show you when the denial letter, when it was issued, when it was written. So if it says August 9th, 2023, you need to calculate 30 days from that day. It includes weekends. So some courts calculate things based only on business days, but the rule is not 30 business days. It's instead 30 days from the date of this decision. So I use a handy app. I just Google, and I can even show it to you if you like. Time calculator. I love a good time calculator. Let's figure out which one. I love it. It's called timeanddate.com. That's the one I always use. And you're going to add days to it. Let's use today as our start date, and we're going to add 30 days to it, and it's going to calculate a new day. That just helps me because I'm not going to mess around with counting on my fingers and looking at it and all this other stuff. You would be Friday, September 8th. And then if your deadline falls on a weekend, there are a lot of different courts that will allow you to slide it to the following Monday. I do not recommend doing that because, again, you then have to show that, oh, wait, it was due on a Saturday and you're not open on Saturday, so you don't receive mail, or maybe the 30th day is on a Sunday. So Monday it rolls over to it. No, no, no. I don't like to sweat it. I don't like to mess with this stuff. I don't want to give anybody any reason for needing to deny me. So I'm not going to mess around with that. But instead, what I would do is just get it there before the deadline, before you start into that weekend. Now, if you don't have a USCIS decision, maybe you don't know what the date was, you can oftentimes look with your receipt notice number. You can enter that in and it will say a decision was mailed to you on such and such date. That's probably going to be the date that the decision was issued. And you could reasonably guess that in 30 days from then, that's when my appeal is due. So if you're meeting with a lawyer or you're trying to figure out what do I need to do, that's at least going to tell you, generally speaking, what your deadline is. I would still prefer to have the actual letter in hand, but if you don't have that, then we got to make do with what we can use. Now, let's say you're not in the USCIS sphere. You're over in immigration court and you got a negative decision from the immigration court. I want to show you, I want to show you this. Okay. So this is one of my actual clients' kind of portal website. This is the EOIR portal. You can see up here. You basically just have to Google, and I have a whole podcast, a whole YouTube video on how to look up your case and how to understand what you're looking at. But the short rundown of this is you Google EOIR. I'll show it to you right now. Let's see if I can do this. You're going to Google EOIR automated case information. The first one that comes up, EOIR automated case information, you're going to click on that. You're going to say, I accept when you get this pop-up. If you don't get this pop-up, your internet is slow and sometimes mine is too. Wait for it because you won't be able to enter anything until you say, I accept. Then you're going to enter your A number right here. Now, I don't want to enter one of my clients' A numbers because then you'll see it, and that's their private A number. It's like their social security number for immigration matters. So instead, what I'm going to show you is I've already entered my client's info and I've scrolled down just enough right here so you can't see his or her name. And I'm going to explain to you what you're looking at here. So what you're looking at here is there's no, on the left, this would tell you if he or she has any more immigration proceedings, any more hearings in court. They don't. Over here, on the other hand, on the right side, it tells you when the immigration judge did what. So on May 7th, a decision was issued. May 7th, 2018, a decision was issued in this client's case. So let's stop right there. If you have been given a decision and it says a decision date here, add 30 days from that, and that's how you know what your deadline to filing a notice of appeal to the Board of Immigration Appeals is. Let me just say that again because it can be kind of confusing. A decision date, an immigration judge denied relief, granted relief, denied reopening, like anything right here that's the first date, that's going to be your initial immigration judge decision. If you don't have one of those here, what you should have is something over here on the left that says you still have immigration court hearings. So you're not eligible to file an appeal yet because the immigration judge hasn't made a final decision in your case. Now, if you've been denied bond, none of that's going to show up here. So if you've got a family member who's in the detention center and they've been denied a bond, none of that will show up here because this is only related to their, like what I call the case, whether they get to stay in the country. A bond case is going to be about whether you stay in the detention center. Only things related to whether you get to stay in the country are going to show up here. So if you've been denied a bond, you also have 30 days to appeal that. And you're going to have to either call the immigration court and figure out when that decision was issued, or your family member is probably going to have been at the hearing when they were told that, no, I'm denying you a bond, and you have 30 days to appeal it. So you'll just have to ask your family member, what was the day of your hearing? Because we want to appeal this. And if we're going to talk to the lawyer about that, or we're going to do the appeal ourselves, we need to know what our deadline is, because that's really your starting point. Okay. So now we know what the date is, and now we can calculate our deadline. So once we know when to do it by, now we ask ourselves, why are we doing this? because if the date has already passed, then the ship has already sailed. We don't really need to worry about why are we doing this. But for me, this is a really important stopping point, because if you appeal for the wrong reasons and you don't have a really good outcome or a really good strategy in mind, the appeal can really bite you in the butt. And here are a couple of ways that an appeal could, in theory, bite you in the butt. So if you are in immigration court proceedings, you go to the judge denies your case, and you've been granted voluntary departure and you're ready to go. You don't have anything here in the US, you don't have any family members or anything like that, but you would like more time, then I think an appeal might be a great opportunity for you. We have to have a basis in fact or law for why we appeal. We can't just appeal to abuse the process, even though it is your right to appeal. You do have to have a legal basis for appealing. This is where lawyers become very handy, because we can find a legal basis kind of in about anything. Okay. So by contrast, however, if you know that you're leaving the country anyway, and you don't want to stay and fight, it wouldn't make a whole lot of sense to start an appeals process. Instead, you would just want to leave on voluntary departure. And even if you need a little bit more time, you can actually work with ICE to get an extension on when you can leave on voluntary departure. So it wouldn't make sense to invest all this money to buy yourself 6 more weeks if you know that you want to leave and you don't want to fight your case. It really doesn't make sense to invest tens, maybe tens, thousands of dollars, depending on what your immigration lawyer charges. And, we don't charge tens of thousands of dollars, but if some people do, it wouldn't make a lot of sense to go that route if, in fact, it's just not going to get you where you want to go. Similarly, if you have a USCIS decision, let's say that you applied for a green card and they denied you based on discretion, like they think that you just aren't a good person and so you're not worthy of being granted a green card, there's actually no appeal of that. A discretionary denial, you cannot appeal it. You could ask for reconsideration, but an appeal on something that they cannot reconsider from an appeals court perspective will be a waste of your time and your energy and definitely your resources. Instead, what I would recommend, and I've not talked to you, but in similar situations, I would say, how can we come at this brand new, no appeal? How can we start this brand new and see if we can refile this and show that you are a person that you are a good person, that you should have been granted this green card, and really starting it from a new process rather than from an appeals process, because the appellate court, the appellate body is just going to say, sorry, Charlie, we don't have any authority to review this kind of decision. So you've wasted your hundreds of dollar filing fee and all of your time. So we don't want to mess around with that if at the end of the day, you're just not going to win, because it's not possible. It's not going to get you anything that you want. Now, one of the reasons that people do appeal is because they want to buy themselves some more time. You can buy yourself a lot of time with an appeal. A Board of Immigration appeal takes like 2 years right now if you're not detained. So if you're out and about, you get denied by the immigration judge and you want to get your affairs in order, or you want to just live for a couple more years lawfully in the United States with your work permit, your social security number, and everything that you had while you're in immigration court, filing an appeal on a legal basis or a factual basis, that's a great option for you. And then if after that you want to appeal again, you could have another 2, 3, even 4 years, depending on how long your circuit court is backed up. If you appeal all the way, here in Arizona, we would appeal to the Ninth Circuit Court of Appeals if your case was decided in the Ninth Circuit. And that process can take 3 years or so. Sometimes more like 2, but definitely have taken more than 3 years in my experience. And combined, that's a total of almost 5 years that you can buy yourself here in the US lawfully. It is your right to appeal. So a lot of times people will think like, crap, I just got ordered removed. What do I do? And then we look forward because they're thinking, I have to leave the country in 30 days, or they're going to come to my house, knock on my door, and come get me. And they come in and talk to me, and I'm like, look, you have this basis for your appeal. If we do this, it's going to buy you blank number of years. And in that time, A lot of times people come up with new forms of relief. They get trafficked by their employer. They marry a US citizen. Their kid, who was 18 at the time, turns 21 and now can petition for dad, who was in removal proceedings. Administrative closure becomes an option. A lot of people who were ordered removed during the Trump administration, we appealed for them. And then once administrative closure, which is like a fancy way of saying, like, we're just going to close your case and put it over here on the bookshelf and not doing anything with it for potentially ever. Those people, we fought and fought and fought and got all the way to the Ninth Circuit. And then their cases got administratively closed, put on the bookshelf, not to worry about, because we went from one president who had one way of doing immigration law to a different president who had a different way of doing immigration law. And so a lot can happen in a few years, frankly, in a few months, sometimes with immigration law. And that is a really good reason for wanting to look into doing an appeal. So now we know when you have to file it. Your personal situation may impact why you want to file it, but let's look a little closely at how you file it, because I think that's an important step, especially if, you can't afford an immigration lawyer at that first stage. The 30-day clock is really just raising the flag and saying, I'm not okay with this and I'm appealing. But you pretty much never have to file, and that's not always true for USCIS appeals. Sometimes you have to file your brief right along with your appeal. But in almost every other situation, definitely for appeals to the Board of Immigration Appeals, definitely for the Ninth Circuit, definitely for the Fifth Circuit, any of your circuit courts, definitely to the US Supreme Court, you just have to raise your hand by filing what's called a notice of appeal within that 30-day window. You don't need to file your whole brief. So if you don't have the money to hire a lawyer right away, or you're not even sure you want to hire a lawyer right away, or maybe you're thinking, hey, I might just do this myself, you have some room to breathe, because all you have to do initially is file what's called a notice of appeal. Or if you're going to the circuit court level, it's called a petition for review. Now, lots of people file petitions for review every year all on their own. This video is not going to go into how to do that, because I really think that you should use a lawyer to file a petition for review. It's just complicated. But if you really need help or anything, email me at hillary@newfrontier.us. And I'll do my best to help you for free so that you can, get what you need to get, at least so your appeal window doesn't close before you file your petition for review. Don't let money get in the way of being able to file on time. I will help you no matter what, to the extent that I'm able to legally and ethically. Get your appeal, your notice of appeal in, even if you can't hire me or anything else. I do not want to see you lose this right, because I have seen how, I'm getting emotional talking about it. I have seen how transformational appeals are for people, because sometimes, my kids are on swim team. I grew up in Kansas. I know they had swim team when I was a kid, but we lived way out in the country, so it wasn't like we could just drive into town for swimming. But my kids do swim team because we live in town now. And the swim coach often will say that even if you lose the race, like a lot of times my kids don't win the race, they'll say, it's okay. He'll say, it's okay. They just ran out of pool. They just needed a little bit more time and maybe they could have won. And I really feel like that's the case for immigrants, where you're swimming and swimming and swimming. You're doing your very best. You're fighting your case. You're doing everything you can, and you just run out of time. You needed a little bit more time in the pool, a little bit more length to be able to swim to win the race. And that's what an appeal does, is it gives you that extra time. And a lot of times the decisions that were made by the lower court or the lower judge, the lower court judge, they're wrong. They're humans. They make mistakes. They look at the facts incorrectly. Or as lawyers, we argue this was just an incorrect way of looking at things. And we're able to help in so many different ways. So let's talk about, what do I do if I go back over here and I look at, and I see that my decision date, that when I was granted voluntary departure, or an immigration judge denied relief, is usually what we see here, is denied relief. We calculate 30 days. Let's pretend we still have it, because as you see down here, we did file an appeal with the Board of Immigration Appeals. I didn't actually file that appeal. I wasn't around for this person's case at that time, but They had a lawyer who did do that. They filed the appeal. And then later on, we filed a motion to reopen. It was denied. And this will be our second time going to the Fifth Circuit for this client, because as you see, this client is in Texas. So we're doing this in the Fifth Circuit Court of Appeals, not the Ninth, because the Fifth Circuit Court of Appeals stands over Texas, okay, and a couple of other states as well. So let's go step by step for this person's case and problem solve. What do we do? So if you are in the situation where it just says immigration judge granted voluntary departure or denied relief, you're going to use this date to calculate 30 days. And you're going to say, that's my deadline. Now, what do I need to file by the deadline? Let's go over here. We go over here to list of downloadable forms. So I'm going to show you. I could not remember the form number, the form that you need to fill out to raise the flag and say, I want to appeal from a decision of the immigration judge to the Board of Immigration Appeals. You're going to click on it. The form is called an EOIR 26, but I couldn't remember what form number it was. So what I did, let me show you what I Googled. BIA Appeal Form E. I knew it was an E because all of them are, but I couldn't remember what the form number was. So if you're like me and you don't want to have to remember it, just Google BIA Appeal Form E, and it's going to give you a list of downloadable forms. EOIR is the Executive Office of Immigration Review, fancy way of saying immigration court and BIA. And it's the first form on this list, okay? So you can also find out what the fees are and that sort of thing over here, and you click. Okay, we're going to click on it and it's going to give us the instructions. It's going to give you the mailing address. It's going to give you really everything you need to know, pretty well broken down for you. So it's easy to understand. You got to pay a filing fee. You got to make it out to the right people. Don't botch the filing fee, because if it gets rejected because of the filing fee, you are screwed. Okay, so don't mess this part up. It is a big problem. So don't mess that part up. We get all the way down here and we're going to start the actual form. This is the part that you fill out and you send in. It's just 3 pages. It's real simple. It's like freakishly simple. And that's why I say, like, if you're down to the wire and you're feeling like, oh my gosh, how am I going to figure out who to hire, what to do, et cetera, et cetera, et cetera, on time, because I have 30 days to do this, don't worry. I'm going to show you how to do it right now. It's super easy. You got this. You're going to list the name and the A number of everybody on this one case. So it has to be one decision that you appeal at a time. You can't appeal like if husband and wife and child, all 3 got denied on the same day, but they all 3 had different hearings, then you're not going to include all of them on this one. You're going to do one for each person. But what most commonly happens, but it isn't every time, but the common way that this works is husband, wife, and child will all have their same immigration court hearing, and the judge will issue one decision for the whole family. Usually like it's a mom and a kid or something like that. And the judge orders both of them removed in the same decision. So the easiest way to know, do I need one for each person, is ask yourself, look at the immigration judge decision, figure out what the date is on it. Are multiple people's names, immigrants' names, listed on this form? If it's just your name, then you can just appeal with one form for you. And then if the immigration judge issued a different decision for your spouse or for your child, you're going to appeal that separately. So I hope that helps. You're going to list your name, and then your A number. Okay. Your A number is going to be that form that's going to be on the immigration judge decision. List your name the same way that it's written there. If it's spelled differently or something, even if it's spelled wrong, don't change it. Use the same spelling that's on the immigration judge opinion decision and put your A number there. Your A number is going to be a 9-digit number, and it looks kind of like a social security number when you look at it. Okay. You're going to say you're the respondent. You're not the government, so you're going to be the respondent. And if you're not in a detention center, then you're going to say, I'm not detained. If you are in a detention center, then obviously you're not watching this video, but maybe you're helping a family member do this. you're going to put that you were detained. Okay. And the reason this is really important is because not detained takes like 2 years for the Board of Immigration Appeals to get to the case. Where if you're detained, they prioritize your case because you're locked up, your family member is locked up, and they recognize that they need to get those cases done faster because your family member's liberty is being impacted. They're not free to leave. How do I find out when my last hearing was at? Usually it's going to be based on what you see right here. Usually a judge is going to issue the decision on the same day, but not always. So you may want to call if you don't know when your last hearing was, you can call the immigration court, Google Dolorosa Street, San Antonio Immigration Court, call them and give them your A number and explain that you're wanting to know when the last hearing was in your case, and they will be able to tell you. My last hearing was at, and I'm sorry, I'm actually skipping ahead a little bit. We don't need to know when your last hearing was. We need to know where it was at. And we can see on this person's that it was, if you don't know, you just Google it and you figure out, where is this? Boom. I copied and pasted the address and we see that it's San Antonio Immigration Court. So I knew that because I know, but I just know that there's only one immigration court in San Antonio and that's the address. But now you can see, just in case maybe you don't know that off the top of your head, you'll know this way. Okay. Let's see here. I'm going to close some of these tabs out. All right, let's get back to this. So we would say San Antonio, Tejas. Okay. We got location, city, state. What decision are you appealing? This is an important one. I'm appealing an immigration judge's decisions on the merits, or I'm appealing a bond, or I'm appealing a motion to reopen. The way you know what you're appealing with certainty is in this situation, we're pretending that none of these other things are here. We're pretending this isn't here. We're pretending all of this isn't here. You would only see an immigration judge denied relief on a decision date. That's when you'll know what you're appealing. And that's when you'll click, I'm appealing a decision on the merits. It wasn't a bond because you're not going to see anything about the bond on that website. And it's dated. Obviously, we couldn't do this because we're outside the 30-day window, May 7th, 2018. Whoop, wrong. And then we go down here and you're supposed to state the reason for your appeal. The reason they want this here is because they don't want people just to file an appeal and not actually have anything that they know about. So a lot of cases, my clients will come in and all I'll have is this information on the EOIR website. And so I won't really know what the reasons are. And that may be your situation too. So a lot of times I'll put something to the effect of the immigration judge made legal and factual errors that warrant the board remanding and to the immigration court. I'll just go ahead and kind of type out what I would usually put. Okay, this would be something I would put. The immigration judge made legal and factual errors in issuing his decision. Upon receipt of the record, and I guess I could put IJ decision, respondent will supplement this statement and will file a brief explaining the IJ's errors and the basis for the board's necessary remand. Necessary might be a little, I'm kind of advocating there, So this basically says there's legal and factual errors. We don't have the record in front of us. We don't have the decision in front of us. Therefore, it's really hard for me to know what to argue. And I'm basically preserving my arguments for the future. If you have the IJ decision, then, you can use some of this as well. And you can explain why the immigration judge made legal or factual errors. So, you could start with this exact same sentence all over again. These legal errors include, and then you go from there. And you can give examples. The factual errors include, and then you can say respondent preserves other bases for appeal that may arise when reviewing the record as a whole. Respondent will file a brief in support of remand. Okay. So this is enough. Okay. I mean, you've got to give some examples if you actually have the immigration judge decision, but what they don't want to do is have you just file with nothing here, because they need you to say something. And if you don't say anything here in this box, then the Board of Immigration Appeals can just basically deny you outright from the jump. So it's really important that you fill this section out. Some attorneys will write, basically a memorandum, 2 or 3 pages. Some will write